The Attorney General is making the case nonviolent felons should not have their right to own a gun taken away. Extra Jack state and local government reporter Jake Stofan is live. And Jake, this isn't the first time the AG has challenged Florida's gun laws in court.
Just recently, Florida's Attorney General James Uthmeier did almost exactly the same thing in a case related to open carry. As a result, a state appeals court declared the state's open carry ban unconstitutional, leading to a statewide policy change. Now the stage could be set for overturning the state's prohibition on nonviolent felons possessing firearms as well. In Florida and virtually everywhere else in the United States, when a person is convicted of a felony, they lose their Second Amendment rights. In Florida, that suspension is permanent, short of being granted clemency, a process that can take years or even decades. Second Amendment attorney James Phillips argues he often sees cases where the penalty simply seems too harsh.
Back in the 70s, when they were 19 years old, they got in trouble for something that was deemed a felony charge, and then they haven't been in trouble since. You know, and for someone like that to permanently be banned from possessing a firearm, a right that our Constitution provides us, the right to defend ourselves, I think it's just too extreme.
And now Florida Attorney General James Uthmeier is making the case it's unconstitutional to suspend nonviolent felons' firearm rights. In a brief filed in a case being heard by a state appellate court, Uthmeier argues laws disarming nonviolent felons are, quote, not consistent with the nation's historical tradition of firearm regulation.
To do a blanket allowance of gun ownership without there being some sort of process of oversight is very concerning from a public safety perspective.
Democratic State Representative Anna Eskamani argues Uthmeier is again attempting to circumvent the legislature to loosen Florida's gun laws, as he did recently with open carry.
I think it's really important for the legislature to be the body that defines laws and for the executive branch to enforce them.
Even if Uthmeier succeeds in overturning the state law, the issue wouldn't be fully settled. Federal law also suspends felons' Second Amendment rights, violent and nonviolent alike. But criminal defense attorney Chris Carson argues the federal government could turn a blind eye, like it does in states that have legalized marijuana.
Because there would just be a lot of volume and a lot going on.
Now, Uthmeier explained in his brief he believes drug offenses do still count as violent felonies, as he argues the drug trade is, quote, notoriously violent. The Florida Prosecuting Attorneys Association filed a brief opposing the AG's view on suspending nonviolent felons' gun rights. That group represents 20 state attorneys throughout the state of Florida. For local coverage, you can count on downtown. I'm Jake Stofan, Action News Jax.